All right, hello and welcome to episode 40 of Ricochet's Law Talk podcast. Welcome to all of you who are joining us here live at Fordham University School of Law here in Manhattan. Welcome to everybody who's listening to us streaming at our online home at Ricochet, and welcome to all the folks who are listening to this podcast through Ricochet or through our affiliation with National Review Online. And special thanks up front to the Federalist Society here at Fordham and to ISI for sponsoring this event and putting up with some of the more extreme demands in the contract. John did not even look at the 6-foot ice sculpture that you provided for him. He just wants to know that you read the contract. So I am the host of the Law Talk podcast. My name is Troy Senek. I'm a former speechwriter for President George W. Bush, which when I say it out loud, I realize sounds like saying you're Marlon Brando's former personal trainer. But it doesn't. I'm also senior editor at Ricochet and a columnist at the Orange County Register. I was third in the recent PayPal balloting. It turns out I wanted to do corporate sponsorships on the MITRE like NASCAR. I am joined, as always, by the Mantle and DiMaggio, the conservative legal movement, swinging for fences of penetrating constitutional analysis. So allow me to introduce you to our Bronx bombers. Richard Epstein likely needs no introduction to a New York audience. You are sort of the Robert De Niro of constitutional law.
I'm the raging bull. And also, by the way, you understand that Jolton Joe and Mickey are part of my Houston heritage, so when you bring me back to my origins, it's always glad. Mantle, I guess, is more appropriate at this point because he had a bunch of bum knees and he hit from both sides of the plate. And the latter, of course, characterizes my intellectual orientation, because I take great joy in letting people try to guess whether I'm a liberal or a libertarian or a conservative. And once you find out the answer, please don't tell me.
Richard, I should note, is the Lawrence A. Tisch Professor of Law here in town at NYU, as well as a senior lecturer at the University of Chicago and a senior fellow at the Hoover Institution at Stanford. And on my other side, you know him from his hit single Gangnam Style. It was just there, I took it. John Yu, Professor of Law at the University of California, Berkeley, visiting scholar at the American Enterprise Institute, and former Deputy Assistant Attorney General in the administration of George W. Bush. For those of you listening, John has just put on a pair of sunglasses. Yeah, that actually eerily make you may want to take those off. Well, thank you both for being here. You have
Wait a second. One prop is enough, but two is absolutely upstaging.
Well, thank you both for being here. You are kind of the Styx, REO Speedwagon double bill of the Federalist Society. So
you just did great movies.
I know nobody in the audience probably has ever. And we've done our show for a couple of years, and you guys have done any number of these together in addition to our show. After all those years of doing these kind of forums together, is there anything on which you've had your mind changed by one another?
Well, John sometimes has persuaded me that I'm even sounder in my original position. If that counts as a mind change, it happens very often.
Well, since I grew up in Philadelphia, I hate the Yankees, and now I hate them more after hearing Richard talk about them from the 50s and 40s. I really couldn't care what they did then.
Okay, so what I'm hearing is your hatred has become more intractable by virtue of this.
I'm so sad.
Oh. All right, guys, well, let's get to substance. Gay marriage, very much in the news since our last show. You had Senator Rob Portman from Ohio, Republican, coming out in favor of it. Hillary Clinton making official that she's come out in favor of it. You had this memo that was released by the RNC, kind of an after-action report that suggested this is an area where maybe the Republican Party should try to be a little bit more inclusive or lighten up a bit. But most salient for our purposes, you've got two huge cases on gay marriage coming before the Supreme Court next week. Prop 8 out of California, the Defense of Marriage Act from the federal level. So before we dig into the questions these cases bring up, why don't we just set the table for our audience both here and listening on the basics of what's at issue here. And John, since you are a Californian, I'll have you start with Prop 8.
Oh, okay, so the Supreme Court case essentially asks the Supreme Court to decide whether gay marriage is essentially required under the Constitution because gays are, well, there's two possible ways that could go, because gays should be a protected class, or that any ban on gay marriages simply so irrational fails what we call the rational basis test. But if you remember the facts of it, California, this has been through our Supreme Court twice. The first time our California Supreme Court upheld they struck down a provision in state law prohibiting gay marriage. And then Proposition 8 was put on the ballot shortly thereafter. The voters of California overruled that earlier decision, and then the Supreme Court, our Supreme Court, upheld Prop 8. Then the case that's going to the Supreme Court now is in federal court. And federal district judge, Judge Vaughn Walker, is a very fine judge. I think one more of Richard's persuasion than mine. He's quite a libertarian fellow, which is why he has such a funny mustache, if you ever meet him in person. Libertarians always have strange mustaches.
No, they don't. Some do.
And he held that there was no rational basis for the state of California to not allow gays to marry when they allow heterosexual couples to marry. And in fact, the fact that California had offered civil unions that were functionally the same as marriages to Judge Walker meant that just banning the title of marriage was really irrational, really showed animus. On the Ninth Circuit, when it went to appeal, the Ninth Circuit actually found on a different ground. They found that Proposition 8 was unconstitutional because it had subjected gays to a harder constitutional process for protecting their rights than everybody else in California. And that's the status as it goes up to the Supreme Court.
Richard, why don't you sort of have the DOMA case for us?
Well, I'll try to run through the DOMA case, but I'm going to do it in very broad outlines. And the first thing to do about the DOMA case is to tell you what DOMA is. And DOMA was a statute that was passed in 1996, and what it was trying to do is to work a delicate compromise over the status of gay marriage at a time when the political forces were not aligned as they were. And it had, as they are now, it has two key components to it, one of which is involved in this case, and the other which is not. And the one that's not involved in this particular case has to do with the question of whether or not full faith and credit has to be extended to marriages recognized, created in one state, when a couple moves into another state. And the general rule on this has always been that with respect to the formalities of marriage, it's the law of the place of the celebration that governs, but with respect to the question of whether it's for or against public policy, consistent or not consistent with public policy, it has always been the place where the couple in fact resides at that particular time. And you need that particular rule because it is always the place of celebration that determines the ultimate issues. Then you find one state in the union that sanctifies gay marriage, it's done there, and then every other state is bound to recognize it. And so what they did is they basically introduced there the same kind of exception to full faith and credit that has always been in the case, namely that if marriage is celebrated in one place, other states don't have to recognize it. This will become moot if it turns out that every state is now required under some cross between the Equal Protection and Due Process Clause to recognize gay marriages because now there's no variation. At the federal level, this was very much tied up with the huge debate over such things as don't ask, don't count. And what they did is the second part of it said, look, when the federal government comes to deal with these particular issues, it is now in a position where it can say that whatever the states wish to do on their own, they're not going to mess with that. For the purposes of all federal statutes, not only those that provide benefits, but those that impose various kinds of burdens, a marriage will be defined in exactly the same way it was defined in the California statute, a legal union between one man and one woman, where the one is at least as important as the man and the woman, because there's no polygamy, no gay marriage under this particular declaration. The history involving Miss Windsor is involving the estate tax is kind of complicated, but essentially what the lower courts did is they said that New York was so convinced of the wisdom of gay marriage that it would have recognized them even before the legislature had so done. So that when the question is whether or not you're entitled to the marital deduction of the federal estate and gift tax at the time of death, you have to follow the state definitions, not the federal definitions. There's a peculiar strand of states' rights that works itself into this discourse, which is completely ironic given everything that was said about the dominance of the federal government when the issue turned out to be Obamacare. And so the lower court struck this down, and there's a combination of irrationality on the one hand and disrespect of liberty on the other. It too is going up to the Supreme Court. And the question now is, as a straight federal matter, will this thing survive? I don't think there's any way that you could argue that the statute is unclear on its face, so it's clearly a straight constitutional play. The Equal Protection Clause binds the states, but nonetheless it's always been applied in a pinch to bind the federal government as well. Due process is both ways. The central debate will be over the following simple question. In Lawrence v. Texas, it was held by the United States Supreme Court that you could not criminalize so-called deviant sexual intercourse. And if that's the case, can you now draw the line and say, once you legalize the practice, can you deny them the right to marry under these circumstances? And it's going to be an extremely tense argument. I should mention this sort of all-star cast in this particular case. Dealing with lawyers, I think it's Paul Clement who is arguing with respect to the defense of it, and a woman named Roberta Kaplan who is arguing on the other side, just as a matter of full disclosure. And a very odd company that I sometimes keep at NYU because I'm an odd kind of guy. That's why I talk about left and right. I'm not sure which way I think the case ought to come out, but I did boot Ms. Kaplan during the course of preparation for this particular argument. And at the same time, I'm working feverishly to develop arguments both to undermine the case for the plaintiffs and to solidify it. So it depends on which day of the week you catch me as to what I will ultimately say.
So, Richard, if you did nothing, the world would remain unchanged.
No, if I did nothing, the world would go exactly the same way it's going to go now. Whatever I say, people will disregard. This is an issue on which fence-sitters like myself will simply not have huge amounts of influence. It's what's so clear is the incredible passion that is brought to this. I think Paul Weiss, which is the firm that wrote this thing, they must have put in millions upon millions of dollars of time and services. An entire entourage is involved in the preparation of this case. It's really quite extraordinary.
Or Gibson, Dunn, and Crutcher in the Prop 8 case, which is being argued by Ted Olson, who was the fellow who won Bush versus Gore for Bush. He's now representing...
See, he's nuts too, right? We all have these kind of neuroses. We just try and figure out how to live with them.
By the way, before we move to summit...
What neuroses do I have? I know.
Oh,
yours are plainly...
We only got an hour. Before we move on, I do want to note, I meant to mention this at the start, for those of you who are here in the room, there are index cards being passed around, and if you'd like to ask a question to either of the professors, we will do that at the end of the show, so just write that out, we'll have those brought up here. John, I want to ask you about the question that Richard sort of brought up towards the end there, the equal protection issue, the 14th Amendment, and you see that at issue in both cases here. There's a sort of intuitive appeal to that. But as we've talked about on the show before, I think at one point you guys had a listener who asked about progressive taxation. Isn't progressive taxation a violation of equal protection? And you made the case that, well, it's not always as simple as, you can't always boil it down to just everybody's treated the same under all circumstances. So what are the implications here where equal protection is concerned?
So you had this question about whether progressive tax rates...
I didn't mean to get
protection clause.
Let's talk about that.
Silly. Oh, well, Richard may think it's serious, but you know, every law classifies people, right? So in those of you in the audience who've taken con law already, you know the question is not whether a law classifies or not and favors some and disfavors others. It's whether the class that's drawn is one that's protected under the Constitution and is entitled to greater judicial protection. And so we don't really know with gays where they fit into the classification, right? The strict scrutiny is reserved so far for racial minorities. Intermediate scrutiny is for gender classifications. So far, in the cases that Richard talked about, Lawrence versus Texas, Romer versus Evans, the Supreme Court has said sexual orientation is not in either of those protected classes, that you have to show the law is completely irrational. It has no rational basis in order to uphold it, and they've said that the two bans issued in those cases were completely irrational. You know, my bigger sense of this case is you know, my policy and constitutional law views conflict here because as maybe as someone under, well, I'm not going to say, someone born after World War II, I don't really have a problem with gay marriage. And I personally opposed the ban in the state constitution before the Supreme Court had decided the case against gay marriage. And you may remember the Bush administration in 2004 or 2005 proposed a constitutional amendment called the Federal Marriage Amendment to prohibit any state from allowing gay marriage. And I wrote an op-ed for which some of our allies gave me a lot of crap, saying that was really stupid and unconstitutional. Well, that was a constitutional amendment, but it was a dumb idea, and that we should let the states decide. That if conservatives are really faithful to their views on the death penalty, abortion, and a whole host of other issues, they should not want to nationalize the definition of marriage. They should let each state decide, as we do with almost all other areas of family law. And so the thing I didn't like about the California Supreme Court was that they took that decision out of the hands of the voters of California. I'm very confident that in the next few years, California will have gay marriage, that if we put it on the ballot, the next few years. I think even polls now show that the majority of Californians are in favor of gay marriage. I fully expect that to be the case throughout the country. Maybe not Alabama, but the rest of the country, slowly over time, I think will be less gay marriage. And that's the way the Constitution intends most questions for us to be decided. I think the worst thing you could do would be to subject just to the kind of judicial politicization and kind of politics that surrounds abortion now. I think that gay marriage will come about over time in the political process. The Supreme Court could only make it worse by trying to turn it into a kind of Roe versus Wade that calcifies the political process. And so it'll become an issue of national discussion every time we have a Supreme Court appointment. And the court's always going to be on the precipice of going one way or the other, and the law will be uncertain.
Richard, how about that? Because that's
I disagree. I disagree with him on a number of points and agree with him on some. First of all, from my point of view, reading the political tea leaves, I don't think this is like Roe v. Wade, because this is an issue which once you legalize it, it's over. And so you don't have the question of partial birth abortions, what you do with counseling, and a whole variety of subsidiary issues which have driven the diff. The second thing is, if I were a Democrat, and I was just thinking realpolitik, I would want this case to go down in flames. The more you keep this in the political arena, the sillier the defenders of the traditional view of marriage as a matter of public law and public rights start to look. As John said, this issue has certainly driven people very much further to the left than they might have otherwise have been. The Republicans may have lost the last campaign in part over gay marriage because gay votes split 3-1 in favor of the Republicans relative to the defendants. The Democrats, and that doesn't include all the relatives like Rob Portman who have friends and therefore straight people who vote that way. So I want to get this out if I were just talking politics. The question of talking law is different, and I'm going to sort of give it the following way. I don't like any of the talk that deals with levels of scrutiny. It's always been highly uninformative in this case, and the claim that Vaughn Walker made that somehow or other it's entirely irrational to have a practice which has been around for 2,000 years and adopted every place in civilization strikes me as nothing short of incredible. The general rule with respect to liberty is that the irrationality test is applied to new and novel legislative initiatives. It's not applied to traditional kinds of practices that have otherwise taken place. And you look at the testimony and some of it saying, well, marriage has nothing to do with procreation. No, this is not two maiden aunts living together. This is about sex, at least in part, and about children, at least in part. And to deny that strikes me to blink at reality. But, so if I go back, and I do this as an originalist matter from 1868, there are two things that you want to know. One is that equal protection had nothing whatsoever to do with civil status. It had to do with the enforcement of the criminal laws. You could not over-enforce them against blacks and under-enforce them against whites when there were any kind of differences. This is an extremely important issue, particularly in the aftermath of the Civil War. And the second point is that all throughout this period, the so-called morals head of the police power essentially meant that every libertarian instinct that you or I might have on marriage could be stuffed down by the majority voters in the state, including the confiscation of Mormon property because of the illegal practice of polygamy. And you take that for you and note that homosexuality was illegal in every state of the Union at the time that the Equal Protection Amendment was adopted. This is non-starter. This is just dead. But there's Lawrence v. Texas. And essentially what Justice Kennedy did is said, I don't care about that history. Forget about those economic liberties. They really don't matter. But this is an exalted high-level freedom. And he didn't call it strict scrutiny. But the way in which he described the transcendental experiences involved with gay marriage, he really thought it was right up there on a pedestal. So it was a strict scrutiny case, whether you like it or not. And once you do that, then the following question takes place under modern jurisprudence, which is if in fact you refuse to criminalize something, can you then say, given that you're the monopolist, that it's now rational to distinguish between those people who do and do not practice it? If the interest is as important as it seems to be on the criminal case, the standard view with respect to any use of state power when there's a monopoly is non-discrimination unless you have a powerful reason. And since the moral stuff is now off the table, there's no such powerful reason. So I would, under the modern law, decide in effect that the challenge was correct. But there's the other part of me, which is the traditionalist, which would decide that it's wrong. So you have to figure out which day I'm on to figure out which way I decided. But we know that every day is a Tuesday when it comes to Justice Kennedy. He will basically, I think, flip over and vote.
But do you think, from what you said, do you think that laws that promote a certain view of morality are unconstitutional. And so beside gay marriage, I mean, what about adultery, I think, which doesn't really harm any, well,
No.
adultery, pornography.
Not a problem. No, let's get.
But those are all laws that the state is advancing a certain view of morality of what's good or bad. It's not like people throw hypotheticals like murder and things like that. Those are not really quite good ones because they do harm somebody. But there are classes of state law, like is Mayor Bloomberg going to tell me what kind of? Well, I don't know if he can. He's going to tell me what kind of stuff I can drink or not. But there are these laws that enforce a certain view of morality, a certain view of trade-offs that we should have in our lives.
John, this is the answer.
Do you think those
I
are
think
all
you're absolutely.
unconstitutional?
No. But listen to what I said. I didn't say that.
No, but I know you didn't say. I'm trying to get you to say it.
No, I won't say that. Because I'm not going to be too shifty. I'm too principled to say something like that. The basic point that I said is, in Lawrence v. Texas, they rejected all the morals justifications in the criminal law, which would allow you to say that this kind of conduct is bad and this kind of conduct is good. So I regard the point of whether or not there's a special state interest involved as having been decided against that. So the only question is, once you decide that you cannot criminalize something, then in effect can you describe that you're going to deny them civil status on the same basis of parity you had in the other case. And so for example, I don't see any trouble in saying that, if you breach a marriage contract and call it adultery, that's grounds for divorce, maybe in some places for criminal sanction, because that head of the morals power still remains involved. Thou took a vow and thou did not keep that vow, and so therefore you're punished. When it comes to the stuff about obesity, there's the question as to whether or not health and safety covers all that stuff. And if you take the modern views on that, the guys who are basically given up on the morals head of the police power become perfectly adamant on health and safety, so it's within that scope. My view about it is I think the mayor is in need of serious intellectual tutoring on this issue. And so that he will basically keep his mind out of my
charges $1,000 an hour.
I hope. I mean,
He can afford it, I hear.
well, he can afford it, but the point is he's not willing to pay it because he already knows everything. But that becomes a different issue. So, as a traditionalist lawyer, I tend to think that the police power issues always have to be considered separately from the basic entitlement question. And the reason you don't have to go that far is it's only in the areas of sexual preference that the Supreme Court has made this particular judgment that the orientation, straight or gay, does not matter with respect to the criminal law. Because remember in Lawrence, what they could have done is to say this statute is bad because it criminalizes deviant relationships only between gay people, not between straight people. They didn't want to do that. They just basically said you just have to butt out of the area. And I think once you say you have to butt out of the area, you cannot discriminate. So I think Kennedy is just wrong to think that
you're like one of the most famous libertarians. I always wonder, do libertarians want to be famous? Because do they really care what anyone else thinks?
Oh, yes, we do.
So, like, you're one of the most famous libertarians in the country. So I would have thought you would like Lawrence versus Texas, and you would like the idea that the state can't dictate morality, and that the criminal law shouldn't criminalize adultery, gambling, drinking too much Diet Coke, or no, it's Coke. Does the ban apply to 32-ounce Diet Coke?
We will find out, and we don't know whether the bubbles count.
But I mean, wouldn't you, as a libertarian, you should welcome the Supreme Court pushing the state out of all of these moral decisions that we should make for ourselves. If we want to, smoke and gamble our way. Yeah, I was going to say, Troy is a smoker and a gambler. I want to give the eulogy at his funeral. But, if you want to smoke and drink and, I don't know, adulter yourself to death, well, fine. The state has no business telling you to stop anymore.
The problem is, now we'll turn this back on John. Because this is the man who's the faithful originalist, right? And it turns out on matters of sexual practice, our Constitution and the understandings of our constitutions were violently anti-libertarian on this area. So the difficulty for somebody like me is if you're a loyal originalist, you can't ignore the background text and history, because then you're just guilty of being a living constitutionalist, which in his world is the most dangerous place you could ever be. It also means that if you're taking John's view, you can't leave it to the states because it's now a moral imperative. My own view on this stuff is, put me in charge of writing a constitution. You'll see a lot less of those folks in Washington.
Can I get a ticket to move first before we do that?
Well, I mean, yes, I mean,
Canada looks really attractive.
I'll let you buy an inauguration, right? I mean, of the things that will never happen is that, I start with the progressive tax. I regard it as flatly unconstitutional with a lot more originalist flavor to it than this stuff. It's just the question, and this is the battle, are you an originalist first or a libertarian first? Because the two are in tension, and that's why I only have joking said Monday, Wednesdays, and Friday on one thing, Tuesday, Thursdays, and Saturdays the other, and Sunday, like all good people, I take a day of rest. Actually, for me, it should be Saturday, but I'm in Fordham, so what difference?
I just thought, because you went from writing your own constitution to, I think, being your own deity there at the end.
Yes, I am. I mean, to thine own self be true, means that I can become dictator.
John, on DOMA, there's an issue with the Obama administration switched sides down the road there. Started out defending the statute, then ended up on the other side of it. Now it's falling to congressional Republicans to actually mount the defense of DOMA in the courts, regardless of the underlying policy. And for the lay listener who's not marinated in this subject area. Is that cause for concern when an administration bails out like that under the defense of a federal statute?
Well, this is a really interesting question about the president's duty to execute the laws. So I think that the president here, I think President Obama here is actually acting within the proper scope of his authorities. If he has decided that bans on gay marriage are in fact unconstitutional, and your point is that he didn't have that view when he was campaigning for office in 2008, but I think a president has a duty to execute the laws, but we don't think he has a duty to execute unconstitutional laws. I think President Jefferson is the first president who invoked this. I think he was right. He said, you remember the Alien Sedition Acts made it a crime to criticize the government, a federal crime to criticize the government. And when President Jefferson took office, he said, that's clearly unconstitutional under the Free Speech Clause. I'm not going to prosecute anyone under that. I think the president can do that. I also think, therefore, by extension, he doesn't have a duty to defend laws that he thinks are unconstitutional in the Supreme Court, right? He's trying to, not only does he think it's unconstitutional, he shouldn't have a duty to try to persuade other branches that, right, that to take the other unconstitutional law should be enforced. So I don't think he has that. Now, there are other things the Obama administration does that troubles me, which is when the administration has said it won't enforce laws because of policy differences. There, I think that's not where the power to execute the laws takes you that far. So, for example, right now the administration is not enforcing the drug laws in states that have medical marijuana. That's fine with me. I mean, as a policy matter, again, I'd be happy if everyone can smoke as much marijuana as they want.
Well, taking the bar in there.
Yeah, it would make teaching a lot easier if the students were all smoking marijuana. But I will tell those small stories that when it's very hard to get students to read statutory codes very closely. They love to read opinions, but not codes. But when the medical marijuana constitutional amendment passed in California, the next day, the students were all reading me through each subsection and what qualified as a doctor to give a prescription of medical marijuana. Way more than I did, far deeper understanding than I held, having read the amendment only once, perhaps. I can't remember what I was talking about. No, but
That's common, actually, in this area.
I'm really hungry.
Yeah.
Does he eat in the show? The little video too? Can I eat some cream?
I'm guessing those students probably read it to you over and over again. Right? They didn't realize it.
Yeah, Beatles song playing backwards. That's also dating myself. So I think that in this particular context, the Obama administration is perfectly entitled not to defend the statute. And I think in those situations, it is appropriate for somebody like the House of Representatives or Congress to appoint someone when the executive branch defaults on that responsibility.
Could I make a comment? Yeah, I'm a little more unhappy about the way in which this thing has evolved. And this has to do with the question of how do you make a determination of whether or not something is or is not unconstitutional. I think if you looked at all of the available precedents out there, what you'd have to say is that the thing was left hanging fire after Lawrence v. Texas, where they explicitly got rid of the criminalization but did not adopt in any way, shape, or form the theory that I just put forward, no matter how persuasive you may find it. So my view is if you're the president, you have to take care that the laws be faithfully executed. You have to come to a very strong conclusion that this thing not only should be switched over as you would like it, but that it's certain to happen in that fashion. I just don't believe that you can make that particular statement. So I don't think he's entitled to interpose his own personal views of what the Constitution ought to do, as opposed to what he thinks the current doctrine says that it does do. Now, mind you, he's bound, therefore, in a way in which an academic like myself is not bound, because I put forward a theory which, if it's correct, withstands strict scrutiny. Right? I mean, we basically have a very tough standard on this thing before you turn it over. And it still survives. But I don't think that he has that particular choice any more than, for example, in some of the immigration cases. He says, you know, I look at this statute, I don't want to apply for people who are in this country for 15 years and now 16 years of age or whatever.
But the presidents have to do that, right? When he or she someday signs a bill, we don't want them to sign unconstitutional laws. They have to make a decision. So you're saying, well, in cases of constitutional doubt, when the case law is not clear or something, maybe they should defend the law. But I think that the presidents have to come to some kind of definitive view whenever they're performing their constitutional duties, particularly whether to veto or sign legislation. I actually think one of the bad things that presidents have been doing for quite some time has been saying, we're not going to decide constitutional issues anymore when I sign a bill. This again happened in the Bush administration. Remember the McCain-Feingold law on campaign finance. There was a provision in the law which banned advertising and picketing and so on within a certain time of the election, which everyone knew was unconstitutional. The Supreme Court eventually struck it down.
5-4.
It was only 5 votes. And President Bush and people in the Senate who were pushing the bill said, well, I think this is unconstitutional, but that's not my job to decide that. I want the Supreme Court to tell us, so I'm going to sign the bill anyway, or I'm going to vote for it anyway. I think that's a reversal of the obligation of members of the House and Senate and the President. They have to have their own constitutional views. They should defer to the courts about what the Constitution means, and they shouldn't sign or vote for bills that they think are unconstitutional.
I disagree. Again, look, I think there's a sharp distinction between those cases in which the law has already been enacted and is enforced, and in those cases where you have an untrammeled right to give a veto. So a president, whenever he wants to veto a statute, he says, I just think this is unwise policy, so I'm not going to go along with it. And at that point, he doesn't have to raise constitutional objections in order to be faithful to his own duty. But once the law is in place, to see that it's faithfully executed is very different from trying to figure out whether it's a law that you're going to sign or not sign. And I don't think he has the degree of discretion. John's position is, I think, also very tricky on the following issue, and it's a long-standing difficulty that we all have, so it's not just John, is John's view is one of judicial parity. That is, the Supreme Court can resist efforts by other people to force it to do things that it ought not to do under the Constitution. But it's not a view of judicial supremacy. And so under these circumstances, let us suppose, for example, that the president thinks that the law is clearly unconstitutional, but there was a 5-4 decision written in no uncertain terms by Nino Scalia saying that this is exactly what has to go. At that particular point, it seems to me that if the president says, I disagree with this guy, you're basically calling judicial parity and judicial supremacy on the table. And my own view about this is I do not like judicial supremacy, but I like judicial parity even less. Because I think the differences between the branches on how you coordinate work leads to too many standoffs and stalemates, and worse things can happen. And so I think he can do this on the signing side. I don't think he can do it on the enforcement side.
Well, that's Abraham Lincoln's dilemma, right? So Lincoln faced exactly that situation with Dred Scott. Right? And if you remember, that's Lincoln-Douglas debates, which we don't teach in law school, but we should, I think. Douglas, who was a judge, state judge, and a very accomplished lawyer, accused Lincoln of being an anarchist. Right? He said, your whole party exists to deny the Supreme Court effect, the Supreme Court's decision in Dred Scott, and you're suggesting you just don't follow the law. And so I think Lincoln's view, which is if this really came into conflict, I think was correct, because everything Lincoln did was correct. Especially since now we make movies out of it. Anything Daniel Day-Lewis does in a movie is constitutionally correct. So he said, especially like The Last of the Mohicans. Right? So Lincoln said that I will execute the judgment in the case of Dred Scott, but I'm not constitutionally obligated to obey the doctrine or the precedent of Dred Scott. That is the Supreme Court's opinion, right? That's why we call it opinion. That's the Supreme Court's opinion defending the judgment. The judgment is that last thing that we edit out of the case books for common law, but the judgment is who wins and who loses and who has to obey what. And the president said, the future president, President Lincoln said, I will enforce that last line of the opinion, because that's the judgment, but I don't have to constitutionally agree with what the Supreme Court says about the precedent. So there is a chaotic element to it, because Lincoln said, if you, the Supreme Court, want to throw all these people back into slavery, fine, you can do it, but you would do it case by case, and you will have a million cases. In order, in each case, that particular freeman be made a slave again, I'll enforce it, but I'm not going to do it myself for you.
I think
and I think that's the right constitution.
I think it's the wrong constitutional view. I mean, we had this exact debate with respect to RFRA and all of these questions in connection with the issue as to whether or not it was constitutional or unconstitutional to create a situation under the Free Exercise Clause where you would refuse to accommodate certain religious practices, including the smoking of peyote as part of a religious observance, which was absolutely harmless to everybody. And what happened was you then got to the situation in which both the left and the right thought that this was completely crazy, and they managed to pass a statute which says that we think under free exercise and equal protection, you're entitled to do all of this. And Justice Kennedy, who's the swing man here, wrote in the City of Bernie case, you know what? You guys have your views on equal protection, but frankly, my dear, I don't give a damn. We are the superior guys in this case, and you cannot extend constitutional protections under equal protection above and beyond those which we have already created. And, you know, that became, I think, the basic standard. And the danger, of course, of the Lincoln position is that it's great when it turns out that you do this in order to make sure that slaves are free, but now you think of it in the period of Reconstruction, and the question is, what are you going to do when it comes to the rights of minority members to vote in local elections? And somebody says, well, you're bound by the decision, but not by the opinion, so you're going to have to get minority black African Americans to the polls case by case, person by person. And that allows you to have massive resistance. So I don't think you really want to take that. Other things that Lincoln did, I think, are right. Like, for example, the question of whether or not he could suspend the writ of habeas corpus. I think it's right because the constitutional text does not give that power unambiguously to Congress, and so you do it that way. But, you know, I'm not a parity guy, and so what always worries me is I think more about the long-term structural implications, or I think more about the short-term particular substantive issue. And since constitutions are there for the long haul, I tend to think more about structure rather than particular outcomes.
Guys, since we have an audience of law students here,
oh, really?
I know you want to talk about legal education, and as you know, I mean, prospects for
the basic
those
message is you poor bastards. poor meant in multiple dimensions.
The prospects for those in the industry are shaky. I mean, we're trying to help, but I can only get arrested or divorced so many times.
Not if the court upholds guilty.
Right, depending on which is constitutional. Well, Rich, let me bring it. You were recently a signatory to a letter on this topic with about 60 other law professors. Let me read an excerpt of this. It's called The Economics of Legal Education. Quote, the price of legal education has risen as the job market for lawyers has declined. More than 2 out of every 5 2011 graduates did not obtain a full-time, long-term job requiring a law degree. The median starting salary of the class among the less than half of graduates for whom the salary was reported was $60,000. The problematic economics are captured by this fundamental mismatch. A graduate who earns the median salary cannot afford to make the monthly loan payments on the average debt. So I'll put the question to you as simply as I know how, and without the profanity that most of the members of the audience would probably like me to include. What happened? How did this happen? What's the solution?
Oh, well, I mean, the solution is much more radical and unprecedented than one does, but this is, the way it happened is there was a downturn in the economy which hit the top end of the market and a revolution in technology that hit the bottom end of the market. And just as I would say in 1940 there were too many farmers given technological improvements, I think now there are too many lawyers given technological improvements. And that the only way that you will be able to get legal care to people who are on the sort of bottom end of the income distribution is to radically reconceptualize the services so that you have the provision of corporate provision of legal services to the large number of people, which will involve relatively few lawyers, because the secret of any mass commoditized service is having intake with a very low-paid piper person, a physician assistant, the teller at a bank. Then you sort through protocols created by fairly complicated algorithms and move the very few cases that need a lot of attention up to higher levels of sophistication. So my view about it is that this will never fix itself. And what you're going to have to do is to understand that the legal profession is going to shrink at the bottom by 20 to 30%, no matter what we do, and that the appropriate thing to do is that the law school market should shrink as well. That is the idea that we will protect through legal regulations under the ABA a part of the institution that cannot survive given competitive realities in the marketplace is over. So that what you then really have to figure out, Fordham, NYU, every place, how much of you can basically go and compete in the top end of the market? Because frankly, there is no middle part of the market anymore. That has been completely collapsed in terms of numbers. You look at Bill Henderson's figures, the guy from Indiana, my former student, and it's just overwhelming. The top of the market, the rich will always be with us, is one of the laments that you hear. As economic activity starts...
Laments?
What?
Laments?
It's a joke.
We love the rich.
No, this is Anatole France. Rich and poor have the right to sit on park benches. They also have the right to practice law. And that part of the market, I do think, will survive. It will take some retrenchment. But the private responses are already there. And so long as you got Dodd-Frank and you got the healthcare bill and the American Invents Act and so forth, there are plenty of things to do at the top. Salaries will decline some. It'll take you 8 years, not 6 years, to become a partner. You get 4 office, not 9 office, or whatever it is. But that will be adapted. And there is nothing, I think, that you can do through regulation that's going to stop the really powerful microtrends.
John, there's a proposal that gets floated along these lines every now and again to basically move law school back to a 2-year experience, to do away with the 3rd year, to make it voluntary, at least. And you have, I think you two have different positions of it, but you're opposed to that idea, right?
Yeah, I mean, I agree with what I think Richard predicts will happen is that the low end of the law school market will disappear. Law schools will go out of business, which I don't think would be necessarily a bad thing.
Well, that's an opportunity for you to start your JD curriculum to the University of Phoenix, right?
Yeah, I mean, it's, I just don't think we need whatever, it's like 200 some, I don't know, that's 200 ABA accredited law schools. There's probably
200 law schools. Which one specifically you think we don't need?
I'm going to stop.
Come on, John, keep going.
But you know, if you have, so you have the lower end of the market dropping out. You also, I think another thing you might end up doing is something they do in medicine, which has what they call physician assistants, and then the whole practice of nursing. We don't really have equivalents to that in law where you are working in the legal field, but you're not a lawyer. You can do some less demanding things. I think that's going to come in the future. But I don't like the idea of getting rid of the 3rd year of law school. I'm just curious, how many of you think we should get rid of the 3rd year of law school?
How many
do you think we should keep it? Oh gosh.
Yeah, for those of you listening, I think we had about half the room that would do away with it.
But there are more, but there are a lot of...
I only counted 4 people said we should have 3rd year.
But only 6 again.
So I actually think that the 3rd year of law school, but then I can ask, how many do you think we should have 3 years of college instead of 4, because you save more money those ways? I think that the 3rd year of law school is actually quite important because I think the one thing after you graduate you will never have a chance to do is go to school if you're a practicing lawyer and learn new fields. So I do think that Richard and I are both at schools, I think, that do this, which I think is a bad trend, is we're trying to push students to do lots of things which are not classroom-based. You know, go do that externship, go work in Washington, take the full semesters of credit. I think those are actually all a waste. I don't understand why you, if you're a student, you want to go into work a year earlier. I mean, when you're at 75 and you're on your deathbed, well, 100. Okay, say you're 100. And you're on your deathbed, are you going to say, I'm glad I worked 81 years? No, you're going to say, I'm glad, probably, I hope that I worked 80 years and I had that 1 year where I got to really figure out what I might be good at. So I think those of you who are in your 3rd year, about to enter your 3rd year, you should treat it as a chance to try to really take things you don't think you're interested in. You might be the world's greatest tax attorney. Well, the odds are very small of any of us in this room being the world's greatest tax attorney, because it really is boring.
What did you say?
But one of you might be, but you would never know if you just take all of their first 2 years in certain years that you like. And so the 3rd year, I think, is really valuable because for you, not for the schools, or maybe even for the profession. I think it's actually a benefit for the students to really try lots of subjects they never will take. Because after you leave law school, the odds are you will never get a chance to experience it again. There are lots of classes I wish I took that I never got a chance to take. I'm not going to admit what those are now, because at Yale they really don't require it. You don't have to take property to graduate at Yale.
You don't have to take law to graduate.
That's both the ones at the school that have.
I went to Oxford too.
So I think that's that's the chance. I wouldn't say find yourself like you think of as college as some kind of personal growth experience where you get to try all kinds of substances that you weren't allowed. Your parents didn't let you try.
Why did you point at me?
Well, you're the one defending smoking. And
no, you're
smoking,
our
gambling, and adultery. I think that third year can be really important for you as young lawyers to figure out what you're going to do in practice. You just don't have a chance in the first 2 years as you.
There are two issues to distinguish. One is do you require it, the other is do you take it. And on the former, again, I'm a strong anti-monopoly type. And so I think a dangerous appendage to the American legal profession is in fact the Bar Association and indeed, in many cases, the organized bar. So when the ABA requires something, my view is it ought not to be required. And when the chief of the New York Court of Appeals requires something, I think he's always wrong. So one of the things that I think is a complete abuse of the licensing process is the mandate that if you wish to practice law, you have to give away free 50 hours to other people. That has nothing to do with your ability to practice law, competence, or anything of the sort. My own view about this is in the first best world, the licensing requirement would disappear, and what would happen is other systems of certification would come up on a voluntary basis, and people can mix and match and sort. So if they wanted to get some recognition as a tax specialist, the area I started teaching, John, in 1968, but you may not remember that.
I was not around then.
But I was. So, I mean, you know, you can do that kind of thing in order to handle it. If you're not going to do that, I think the correct rule is if you pass one bar and practicing in good standing for 5 years, you could practice in any place in the United States.
Oh, so Richard, you would get rid of the bar exam entirely?
Well, I mean, look, I think if you got rid of it,
voluntary bars.
I think if you got rid of it,
5 people, it's like the Holy Spirit. Like
yes,
you could be together, and all of a sudden you pass the bar.
No, I mean, look, I mean,
would just like a doctor operate on you, not taking any medical boards, you just sort of hang out a shit.
Yes, I don't
trust me. I'm a doctor.
John,
actually, we have a lot of those in California.
Market Economics 101. If you don't have a bar certification system, what will happen is that people will originally start with firms or brands which will protect them, and they will not screw up because the branded entity will keep them under control. And the way in which we practice medicine now is heavily driven by these kinds of groups and organizations. And I can assure you people don't care after 2 years whether you had the boards or not. They want to know whether or not you've got good surgery rates. And that is better done through comprehensive evaluation by basically the host institution, which in fact is routinely done today and is much more effective than the licensing system that we have. We also use licensing for all sorts of other collateral purposes, like, for example, mandatory participation in these markets with Mr. Lippman, who's the Chief Justice in this particular state. And I think those things are a mistake. What happens is you can't assume when you get rid of the mandatory system that voluntary mechanisms of a rating nature will not grow up to fill the gap. And those, I think, will turn out to be much more responsive. And there will be much less danger of restrictive practices of the sort that we have right now. Now, whether people will take it or not, well, I think this is the attitude. It's my guess if you want a big firm practice, and I speak to a lot of these guys, I work for a lot of these guys, their problem with you is that they don't think you know enough law, so that they have to tutor you, and clients don't want to pay for tuition in the form of salaries for first-year students. And let me just say this, we have more information now and more techniques now than we've ever had to teach before. You look at 1930, what we call the property course was 8 separate courses at the time. You had a course in bailments, a course in personal property, you had a course in future interest, a course in estate, a course in mortgages, a course in leases, a course in conveyancing, a course in servitudes. Now we just call it property. But you didn't have environmental law, you didn't have pensions law, you didn't have civil rights laws, you didn't have health care law, you didn't have any of the big statutes. This stuff you can't learn on the fly. So I think, in effect, at the top end, people will continue to stay in the business. And that what will happen is you'll have a smarter business because you have much more entrepreneurial people running it, and the hopeless fuddy-duddies who organize the bar examinations, who are too slow by half, will no longer have any influence, which I think is something to be devoutly desired.
Okay, let's conclude here. We've got a couple of questions from the back. It looks like one for each. So, John, I'll give you the first one. Since you were born after World War II and are not upset by gay marriage, would it be okay for someone born after Vietnam not to be upset with incest marriage or polygamous marriage? Please cite examples.
So, obviously I was saying that my point was that social norms are changing. And if you look at I think if you look at the polls, the last ones I saw, the real difference on gay marriage is generational. That there's, for people who were born before, I think in the early 1950s and before, strong opposition to gay marriage. If you look at people born in the 60s and later, it's already, if we could take the vote that way, we would have had gay marriage years ago. So there is something about this generation. The things about, what was it, incest and what was the other one?
Polygamous marriage.
Polygamy. Oh, that's the one I really want to try.
Okay.
Incest, not incest, polygamy. Incest marriage has social harms. I mean, I think that's actually a relatively easy one, is that, incest produces all kinds of harms, and we worry about coercion. So I don't, and polygamous, I think that's an interesting thing, because I think if you, for lots of reasons, because I've seen things. Now, if you,
You're being filmed.
Come on, John,
if you're willing to go gay marriage, what's the difference? What's the real difference between gay marriage and polygamous, or some of my colleagues write of polyamorous marriages, where you just have group marriages, where it can be any combination of people, I suppose. And I find that interesting. I mean, I'm not sure whether once you go down the line of gay marriage, whether there's a legal difference, a constitutional difference, if you take this idea that there has to be a rational basis, because you want to show what's the harm to people who live in a polygamous marriage versus a twofer marriage, whatever we're going to call that now, a twofer marriage. And so, under Judge Walker's analysis, you're going to have problems with that. I don't think, though, that social norms have changed on polygamous marriage yet, even for people born after World War II. Although I take it, Vietnam, although I take it lots of young people now go on group dates, so maybe that's the precursor to polygamous marriage.
They're going for a malted. Let's keep it straight, Joe.
So my point is just that I don't think I've not seen polls on polygamy or polyamory or whatever, but my sense is that there's not even close to majority desire to have those.
Yeah, I think you get it exactly backwards. The reason we have to protect
that happens a lot in these kinds of
polygamous marriages is why should the majority determine the intimate personal relationships of the minority? The whole argument that Kennedy made 12 years ago was, I don't care what popular votes are, it's a private relationship. As to polygamy, it has the virtues that is actually involved with sex and reproduction. It turns out that it was a successful system that operated in various kinds of cultures, mainly the Mormon, but other places as well. If you look at what Justice Wade said about it when he talked about it in Reynolds, you will not be amused. He's basically treated as an institution for savages who live in places like Africa, but would never come to the benighted civilizations that we have in Western Europe. It was a really kind of ugly sort of racist overtones to it. And then you ask what the harm is. Well, there's always a risk of coercion, but that means we get rid of all marriages because we understand that abusive spouses are always there. It's just over being done. And my sense about it is that the last thing we want to do when we do a constitutional analysis is to figure out whether it's popular sentiment. I was on this Ask Me Anything Reddit show, and somebody said, what's your views on polygamy? And I said, well, I'm in favor of it, my wife is against it. But
if your wife was smart, she would want more husbands.
But that's polyandry, is a different situation. But what I meant by that is I was in favor of it legally, and if there's no demand for it, all the more reason to legalize it, because it's not going to happen. And when
my point wasn't that it's the constitutionality of it one way or the other. My thing is that people should just be able to vote to have it. So if the voters in California want to have polyamory or polygamy, fine, let them.
But I don't want the voters to decide how other people run their lives. Remember, with the stuff on gay marriage, there's no religious issue there. With respect to the whole question on polygamy, there is a free exercise clause challenge, which is an explicit guarantee. And so there, the level of scrutiny ought to be higher against it. And my view about it is they can't make this case out. And people have to just stop freaking out when somebody goes into the supermarket with 2 wives and 3 market baskets. It just, learn to ease yourself in your pain. It becomes useful.
What's their favorite fruit?
Well, we can make all sorts of jokes about it. But I will not answer anything further because I'm probably getting close to seditious libel, although I'm informed, thankfully, that it's unconstitutional to punish me.
Let me give you, there's one final question for you, Richard, so you will have the last word, because I think we all know is inevitable. Do you see a contradiction when liberals argue for a progressive tax system, but at the same time argue for same-sex marriage? If the government shouldn't be able to discriminate against gays, why should they be able to discriminate against the 1% and others?
Well, you're asking the wrong guy on this. I did write a book called Takings, which had the modest thesis as a mere afterthought around page 315 that the entire progressive New Deal structure was flatly unconstitutional. And I still believe all of that, and I think that wholly apart from any pragmatic type considerations, the analytics are very clear about this, and that pragmatically it's even stronger. And I would say the following, and everything depends upon the level of scrutiny. And the reason that I am basically opposed to the progressive tax is that I think it's a massive transfer from A to B. And I don't think that that's what's government about. I think government is about curing a serious public goods problem and of violence and disorder, providing infrastructure and so forth. And that the ideal system of taxation, to the extent that we can do it, has a couple of main goals. One is that you want to make sure that you have enough power to send to sort of prevent aggression from taking place and to supply infrastructure. You cannot use voluntary means to secure it. And two, you want this thing to be flat, because the moment you make it progressive, you'll have exactly what we see now. Short-term tax compromises, all sorts of cliffs. Nobody can do any long-term planning. And the more you get redistribution at the top, the more you get a decline in income standards at the middle. So that under the Obama administration, growth has been basically zero in real terms. Real income at the middle is down 9%. That's a tax which we don't talk about. If you would flatten the rates and increase the growth rate by 2%, which is achievable, you'd have an extra couple of $1 trillion by now to pay with on a $14 trillion economy. So I think that all that stuff is just crazy. To the other people, their attitude is what John said. It's suspect classification time. And there's nothing about wealth which is suspect, because the progressives have been doing this since at least Pollock and Farmer's Loan in the 1890s. Woodrow Wilson, probably our worst president ever in terms of domestic policy, was a champion of all this stuff. He was also, by the way, a pretty determined racist, so don't understand the complexity. I think it's just all wrong. And that if we went back to a more limited, less discretion government, we would have both gay marriage on the one hand, and we'd have a flatter tax system, and we'd have higher levels of progressivity if you take into account the way this thing plays out in the long run. So liberty and justice for all is, I think, attainable by we the people. Thank you.
All right, well, in closing, I'd like to thank several people, including whoever the mischievous individual was who gave Richard the opportunity to dismantle the New Deal with 5 minutes left in the program. Thanks to ISI and the Federalist Society for having us. Thanks to everybody listening at Ricochet and National Review Online. For John Yu and Richard Epstein, I'm Troy Sinek. Thank you for listening to this edition of Law Talk.